stakeholders a range of topics related to toxic use reduction in Massachusetts and beyond. Pam introduced me already. My name's Colin Hanahan. I'm a policy analyst at Turi, and I'll be moderating today's event. Today, we're going to focus on the complex landscape of policies, rules, and regulations which influence how chemicals are used. Of course, we're all familiar with the Toxic Use Reduction Act of Massachusetts, but there are a range of other policies which exist at the federal and international level, which may present challenges and opportunities both for businesses and other stakeholders. So today, we're very lucky to have three experts, well, at the moment, two experts, but three experts with experience in these different policy arenas at the international and federal level. So we'll hear from them and then hopefully have some time for a panel discussion after. So feel free to people in the audience to use the chat to ask any questions. And we'll consider fielding those after each speaker and during the panel discussion. I'm not sure if Chair Decker was able to make it yet.
She will be logging on in the next few minutes. I'm so sorry.
Okay, no problem. Thanks for letting us know. I can quickly introduce her, and if she's still here, if she's still not here, we can move on to Richard or maybe try to make a little more time. But Representative Marjorie Decker of the Massachusetts Legislature has represented the 25th Middlesex District since 2012. She is the co-chair of the Joint Committee on Public Health, which is a very important committee within the legislature. And in this capacity, she and her staff have carried out significant work to strengthen the omnibus PFAS bill in Massachusetts, which is currently moving through the legislature. Perhaps I can just give a quick bio on the other two speakers while we wait. So after we hear from Chair Decker, who will make some opening remarks, we'll hear from Dr. Richard Engler, who is the Director of Chemistry at Bergeson and Campbell, which is a DC law firm that helps companies make and use chemicals while maintaining compliance. He is a 17-year veteran of the Environmental Protection Agency of the US government, having served as senior staff scientist in the Office of Pollution Prevention and Toxics, and was the leader of the EPA Green Chemistry Program. He is going to speak on some key elements of TSCA, which is the federal chemical regulation framework here in the United States. Very lucky to have him. And then after Richard, we will hear from Kastalie Bougas. She is a policy officer and economist in the Safe and Sustainable Chemicals Unit at the European Commission. She specializes in critical regulatory issues related to chemicals, and this includes the essential use concept and PFAS restrictions, which she will cover today. So, very exciting roster of speakers on these topics. Looking forward to the agenda and seeing, how these different policies can work together, how they might influence businesses in Massachusetts and beyond. And hopefully it's helpful for those people in the chat and maybe beyond as well. I hesitate to start with Richard because I know he has a substantive.
Rep Decker has just joined us.
Oh, that's great news.
So if you could unmute yourself, there we go.
Yeah.
Stop sharing my screen so she can have the floor.
I just thank you for having me. I want to say good morning to everyone, and thank you to everyone who's on this call. My understanding is that you're all playing a really important role in the work that we do to both educate the public about the dangers of PFAS in our that exists and where it exists in all of our lives and how it exists, as well as helping us think through how to navigate the current use of PFAS in our life, as well as how to transition out of that. So as chair of public health of the Massachusetts Legislature, just to say thank you for the work that you're doing every day, and for many of you who've been really important partners to both myself, my committee staff, my colleague, who is the co-chair in the Senate, Senator Julian Cyr, and the House sponsor of the primary legislation that we've been looking at and using as a vehicle this session, to our Speaker Pro Tem, House Member Kate Hogan. So just to say that in Massachusetts, there's been a lot of work done, and there's been a lot of effort to really study what are the impacts of PFAS in Massachusetts. We know that over 96 communities across Massachusetts are impacted in their drinking water. We know that these chemicals, you know, I'm talking to a group of people who actually already know why this is a problem, and what the impacts are on our health, where it permeates in our water, our air, our soil. And I can just say that I'm really excited about the work we're still doing. The session's not over. And the upcoming session, in which we will pick up any work that we weren't able to get over the total finish line. So this year for the Public Health Committee, one of the things we did was take a look at this comprehensive bill that would limit and prohibit PFAS from certain consumer products and food packaging, while also providing additional financial assistance to make sure we can actually help transition what those changes would look like where we prohibit them. That bill was worked on extensively by our committee staff, including some of you through organizing this have gotten to know Daniela, who has been an incredible. Daniela never knew that she would become so intimately familiar with the science around PFAS, but has really dedicated, I think it's probably part of her identity professionally at this point, for the amount of time and effort that she has helped us put into looking at this issue. And we redrafted the bill. And we feel really good right now about the bill, that if it were to pass in Massachusetts, would have a really strong impact in helping us to start eliminating PFAS. We know that, as they're often called, the forever chemicals, we can't get rid of them once they're already used. But we know that there's also a lot of science and innovation happening even here in Massachusetts that's trying to combat that challenge, of how do we actually do get rid of them once they're here. But the most important way to do that is prevent them from being used. And so at this moment, we were able to, one of the parts of the bill that I'm really excited that we worked on with the both the Massachusetts firefighters and the International Firefighters Union, was language that will now actually prohibit PFAS from being used in turnout gear from firefighters. In 2020, I was able to spearhead, prior to being chair of public health, legislation that prohibits PFAS from flame retardants from being used in children's toys and furniture. So Massachusetts has already been ahead of the curve nationally, where we started there. But getting some of them out and not all of them out is not the solution. You know, there's probably not one person amongst us in this country who doesn't actually have this toxin sitting in our bloodstream already. So all I can do is to say is that I'm really excited to be part of a community that understands the importance of this work, the urgency, the public health crisis that exists, and to say to you that as the chair of public health, I could not do this work without your support and yet your collaboration and your partnership. We have phenomenal staff in our committee, but we also have so many different issues that come before us as legislators, that our job is not to be expert in the fields, but our job is to be expert at identifying the experts who can help us make sure that when we are looking at legislation, and in particular this bill, that we're using science-based evidence that says, this is the reality. These are the facts. This is where you know, moving from A to B will actually either improve or harm the outcomes of the public health. And that work has been essential with all of you, because, as you know, the other challenge here is always, and the industry will always do this. I've likened the industry, you know, and in fact, we know that they're the same investors often, but it's not so different from the tobacco industry, in which they know that they're producing consumer products that absolutely, unquestionably, not only harm people and make people sick, but ultimately kill people. And so our job is to be able to tell the story of how do we actually transition from the use of these chemicals, which is embedded in so many of our everyday products in life, and be able to also tell the story of what an alternative looks like. And many of you are also, I know, doing that work. What are the alternative to these chemicals? Because we have industry that is very invested in showing us that, in fact, we can't live without them. And we know the truth is, it's true. We can't live with them. And so just the flip side of this is being able to make not only the public health argument that's science-based, but also being able to provide alternatives and assuring legislators and constituents and stakeholders that this is also not going to implode our local economy. And it's also not going to, I think, be a conflict with federal laws that sometimes make it more difficult for state legislatures to be able to implement these. And I was really proud that while those arguments were used against us when trying to take flame retardants out of mattresses, as an example, we were able to show, in fact, that state legislatures can lead on that and that there are alternatives. And in fact, when state legislatures act on this, what we know is that the consumer industry that produces the products, they then run to find an alternative. But if they're not being held accountable and being forced to find an alternative, then they'll just keep using what they have to seek the profits out of consumer products and food packaging and everyday things that just, while might add an extraordinary level of convenience that we've become comfortable with, there's a high price that we're paying every day. And not only are we paying the price individually, but collectively, there's a price on the taxing of our healthcare system and the treatment for the sickness that is caused by these chemicals. So all I'm here is just to say is enthusiastically is just thank you for the really, really important work that you do, and for the and for ensuring that you are able to help translate the important work that you're doing into a policymaker's conversation that we then use to change laws and hopefully improve and save lives.
Thank you very much, Chair Decker, for those words. At Turi, and I'm sure the toxic use reduction planners are very happy to have policymakers engaged on this issue, especially through a lens of reducing the use in the first place. So very happy to hear that and excited to see how the work to govern PFAS use in Massachusetts continues this year.
Yeah, we're going to get there. It's a matter of, is it, next 2 months or is it the next 4 or 5 months? But we're going to get there, and that I'm confident. So thanks for all of your collaboration and support.
Of course. Thanks for taking the time to make these remarks as well.
Thank you.
Okay, great to hear from Representative Decker with the perspective from Massachusetts, especially with a focus on PFAS. We know that a lot of the work in states is at the forefront of this issue. So now, I already introduced him at the beginning, Dr. Richard Engler from Bergeson and Campbell. He's the Director of Chemistry at Bergeson and Campbell. 17-year veteran of the EPA, and he'll be speaking on TSCA, and that's the federal chemical regulation framework that we have in the United States. So, Richard, the floor is yours.
Thank you. So I'm going to give you, this is going to be a very, very, very quick run through TSCA. I want to start with the statutory divide. I want to make sure everyone's aware of the limits of TSCA and its applicability. Then I'll talk about where things stand on existing chemicals review under TSCA Section 6. A quick update on this, on the state of where things stand for new chemicals under TSCA Section 5. I probably won't have a lot of time to talk about testing and data gathering, but hopefully I'll be able to touch on that. And then I'll also mention some opportunities to be involved. Okay, so first I want to make sure that we're level set here. TSCA is one of the 3 federal chemical control statutes. There's the Federal Food, Drug, and Cosmetic Act, FDCA, which covers food, drug, cosmetics, medical devices, and components thereof. So if something is manufactured or processed exclusively for food, drugs, medical devices, cosmetics, including personal care products, it is excluded from TSCA authority. EPA does not have authority under TSCA to regulate food, drugs, or cosmetics. FIFRA is the Pesticide Act. It controls pesticides, federal food, or Federal Insecticide, Fungicide, and Denticide Act. It includes antimicrobial products, biocides, herbicides, broadly, basically anything other than a drug that is used to mitigate or control or destroy an organism. TSCA is the catch-all. It's very interesting to read the definition of a chemical substance under TSCA because it starts with like what you would think a chemical substance would be, but then it says, but it excludes, and it lists all the products that are regulated by the federal statutes, in particular food, drugs, and
Rich,
cosmetics.
I'm
Yeah.
so sorry. Could you just move your mic down a little close? Thank you.
Is that better?
So much better. Thank you.
Okay. Yep. So, so the substances that are regulated by the other federal statutes are written out of the definition of a chemical substance under TSCA. It's also important to recognize that if you have a substance that's used for multiple uses, more than one, that substance has to comply with each of the statutes. So if you, ethanol is sort of my favorite example of that. Ethanol is a food. It's used as a food additive. It's used as a drug. It's used in medical devices. It's used in cosmetics. It's used as a pesticide, and it's used as a fuel additive, for instance, in gasoline. So that would be regulated under TSCA. So if you're making ethanol and you're selling into each of those uses, you have to comply with each of the statutes. Okay, so let's turn to TSCA now. This is the way the existing chemicals review process works under TSCA Section 6. EPA is required to review all existing chemicals, all the substances that are listed on the inventory. There are about 44,000 substances that are listed that are active in commerce, and EPA is required by the statute to review them all. The process is this three-step process: prioritization, where EPA designates a substance for high priority or low priority. Basically, the only EPA is not going to be putting things up for low priority designation. They don't have the bandwidth, and there's not a lot of value to making low priority designations. So EPA is doing high priority designations, and I'll talk about some of the substances that are being considered for what's being prioritized now and what's being considered for prioritization. If EPA concludes that the substance may present an unreasonable risk, it is then the EPA is required to take it forward for risk evaluation. And I'm sorry, prioritization is 9 to 12 months, so a little bit less than a year for prioritization. If they conclude it's high priority, they must take it to risk evaluation. EPA either concludes that the substance presents an unreasonable risk or does not present an unreasonable risk. The risk evaluation process is 3 to 4 years. I think nominally it's 3 to 3.5, but those timelines have been fuzzy so far. There are also some questions about interpretation here that I'll talk about in a little bit. If EPA concludes that there's an unreasonable risk, then EPA is then required to issue a risk management rule that eliminates, the EPA must issue some regulation, some restriction to the extent necessary to mitigate against the risk that EPA identified in the risk evaluation. And the risk management process is 1 to 2 years. And I think importantly for this audience, risk management includes an alternative assessment. So EPA is required by the statute to look at alternatives, and EPA has to essentially suggest alternatives that have environmental and or human health benefits. I think for me, as a green chemistry proponent, I've been very disappointed by EPA's alternatives assessment. I don't think EPA has really got the expertise to do it. If you look at the asbestos and really the methylene chloride rule, I think is a better example. If you look at the methylene chloride rule and the alternatives assessment in there, it's not what you would see if one of the alternatives assessment that the Department of Ecology out of Washington State did. Those are, I think, excellent alternatives assessment. EPA is basically saying, hey, we found benzene as an alternative to methylene chloride. I don't think that's a particularly good alternative to methylene chloride. I would classify replacing methylene chloride with benzene as a regrettable substitution, but that's my personal opinion. Anyway, so this is the process, right? So if each substance is about 5 years, then and EPA has over 40,000 to review, I think we can all agree EPA is never going to get to them all. EPA's goal is to review 5 per year, so it's going to be a while before EPA makes a really meaningful dent in all the substances that are listed on the inventory. Here's where we are with the risk management rules. So these are the first 10 chemicals that EPA evaluated, performed risk evaluation. 2 are already final: asbestos part 1, which is chrysotile asbestos, and then methylene chloride. Those rules are final and in effect. They've both been challenged in the courts. There's going to be some interesting discussion over what some of the key terms are in TSCA. This is really the first time these terms have been litigated. Things like what does it mean, the extent necessary, what does that mean? There's some debate about what is an unreasonable risk, what's the meaning of an unreasonable risk, and then the interplay of various parts of the statute, the risk evaluation, the risk management rule, and EPA's requirement to coordinate with other federal agencies, and EPA requirement for EPA to use to consider using other federal authorities within the agency to manage risks. Carbon tetrachloride, PERC, and TCE are final, and we expect them out any day. We heard they were waiting until after the election. The election's over. We expect these all to come out in the next 2 to maybe 6 weeks. So we'll see those final rules. These, I think, will get at some of the questions about best available science. We don't know exactly what EPA is going to do to establish, say, the workplace protection standards in terms of exposure limits in particular for carbon tet and TCE, where there was some real questions about the underlying science that EPA was relying upon. So we'll see what those final rules say, but we expect them shortly. 2 rules have been proposed; they're not yet final: NMP and 1-bromopropane. NMP also suffers from some questionable. Did EPA rely on the best available science? Is it appropriate for EPA to rely on the study results of a study that cannot be reproduced? So if you do a study and you get an outcome and you do the study again a couple times and you can't reproduce that original outcome, which one is the best available science? So that's one of the key questions for the NMP final rule. I don't think those will be final soon. I mean, they might try to rush one out before the end of the administration, but that would surprise me. I'm not sure they're going to have the bandwidth to do that. They've got to get other rules out. They've got risk evaluations to get out. There's a lot on their plate that they're going to try to do before January. Rules that are pending proposal are pigment violet 29, HCBD, and 1,4-dioxane. Whether they try to propose these rules before the end of the administration is another question. Which is more important, proposing or getting the rules out final, or getting the rule proposals out. EPA is late on basically all of these. They've missed the statutory deadline for all of them. So it's not really clear to us what's going to happen with these various rules. EPA's got 20 that are undergoing risk evaluation. We call these, so that this set was the first 10. These are the next 20. There are draft risk evaluations out for formaldehyde, 1,2-dichloroethane, 1,1-dichloroethane, and TCEP. Risk evaluations are in development for the rest of these. I think probably the most mature one is the 1,3-butadiene, based on what we've heard. EPA ordered some testing on some of these, and that testing is ongoing to one degree or another. So EPA is still waiting for the results of those testing, that testing to inform the risk evaluation. But EPA is mostly in the data gathering and analysis stage for these 20. EPA has already designated 5 that will replace, as EPA finishes 5 risk evaluations. They're required to initiate prioritization on 5 more substances. These are the 5 that will go in: acetaldehyde, acrylonitrile, aniline, MBOCA, and vinyl chloride. So we're in the prioritization process here. EPA has not started risk evaluation. There's already some jockeying about, from stakeholders across the political spectrum about, what should the scope of the risk evaluation look like? Does a risk evaluation of vinyl chloride necessarily include the use of polyvinyl chloride as a polymer? Is it appropriate for EPA to use its authority in that way and take an intermediate, what is essentially an intermediate, and seek to regulate the final product that's made from that intermediate? These are some interesting scientific and legal questions that I think will play out in some of these. EPA is also EPA selected these 5 from a longer list that included these substances, which are basically in an informal stage called pre-prioritization. These are things that EPA is thinking about putting up for prioritization, including 6 PPD. EPA has actually granted a petition that it will review. It will perform a risk evaluation on 6 PPD, which, if you're not aware, is a tire rubber additive that protects against the oxidation of the rubber in tires, helping improve the longevity and the performance of tires. 6 PPD, in fact, it's the 6 PPTQ, the quinone that's formed, the breakdown product of 6 PPD is actually, it was discovered a few years ago that it's quite toxic, unusually toxic to salmon. This was discovered in the Pacific Northwest. It was traced back to the 6 PPD tire rubber additive. And so there's a lot of concern about 6 PPD and its effects of the degradation product on the environment. So that's why that's in this bucket. EPA also earlier this year, actually in October, put up a bunch of other substances into the pre-prioritization bucket. Really not clear why they did that. EPA is just, I think they're looking more broadly at what else is in their queue, and they're seeking input. What do stakeholders, again, across the board, think that EPA should focus on for the next 5? They can't do everything, right? They've basically got the bandwidth to do about 20 at once. They're about to wrap up 4 or 5 from the next 20. And so what's going to replace that? We have 5 that are going to replace that. They're starting to think ahead about what they're going to do behind those next 5. They need data. They need hazard data. They need exposure data. They need information to bring in. So they're looking for input on what's important, what's critically important, and then where and which of these have data, or if there's not data available, how might that data be generated so that EPA can evaluate. So that's existing chemicals. There's a lot going on. I think we're going to see, we've got court cases that are going to affect the risk management rules. There's actually some court cases related to risk evaluation outcome. And then we've got the jockeying over the prioritization and the science and the risk evaluations. So it's certainly a very interesting time to be a TSCA practitioner. TSCA, even though it's about 8.5 years old now, there's still a lot of legal questions that are outstanding that this litigation. And Lynn Bergeson, the managing partner of the law firm and the president of our consulting affiliate, the ACTA Group, her view is that litigation is actually healthy. It helps establish what these key terms, Congress wrote the law, and then the question is, what do those terms mean? Reasonable people can disagree, so you make your best argument, and then the courts are going to decide. So that's sort of where we are. New chemicals has been particularly frustrating for me as a green chemistry, and I'll talk about it a little bit. As a green chemistry practitioner, I've been very frustrated by the way new chemicals is being implemented by EPA. Again, reasonable people can disagree on how it should be done. One of the problems is that reviews have been very protracted. There are a lot of reasons for this, not the least of which is that EPA has been relatively under-resourced, but I also think EPA is overanalyzing. I think my personal view is that they're spending too much time thinking about individual cases rather than look at the facts, make a decision, and move on. The statute it gives EPA 90 days to review with a potential extra 90 days. The average since enactment is 470 days. So if you are a new chemical innovator, you're a green chemistry innovator. We certainly have a number of clients who are. Or you're trying to bring something, some critical product to market. We have a client that's developed a filter media that it's extraordinarily effective at removing PFAS from water, from all sorts of water, not just drinking water, but drinking water and wastewater and polluted water. It's very effective at removing PFAS, and the filter media can be regenerated instead of incinerated, which is what's mostly is done with the activated carbon, which is the state of the science now. EPA took, despite the critical need for it, EPA thought about it, and really EPA's only concern was, well, what if people inhale this what is effectively an unreactive dust. So we eventually got EPA to issue us a regulation that allowed us to allow the manufacturer to proceed to market, and now they're ramping up production because there's a huge demand for the filter. their EPA finds, so their EPA has to make a decision when you file a PMN. EPA has to decide, will the substance present an unreasonable risk, which is a very unusual outcome. The substance may present an unreasonable risk, or the substance is not likely to present unreasonable risk under the reasonably foreseen conditions of use. EPA has yet to define what it means to be not likely to present unreasonable risk under the reasonably foreseen conditions of use. Again, 8.5 years in, and there's no clear elucidation of what that means. What EPA is doing is, if EPA identifies a hazard other than low hazard, so if it's not low hazard for health and low hazard for eco, EPA is issuing a regulation, and then that leads to some commercial disadvantages. It's called the new chemical bias. There's a lot of disagreement about whether or not there's a new chemicals bias. I can tell you from a lot of our clients' perspective, there's a huge disincentive for new chemicals bias. But that not likely to present unreasonable risk is the outcome that submitters are trying to achieve, but fewer than 10% receive this determination, even for some very, very green chemicals that we've been assisting with. So that's a real challenge. And what happens is, when EPA issues these orders and they promulgate significant use rules, there is a market disincentive, because these orders and SNRs carry enforcement risk. You have to have records documenting that you've met the requirements. And you think, what's the big deal? Like EPA asked this when we raised this question. They're like, well, we issued a regulation that said you can do what you want to do. And it's like, well, it's not just that we can do what we want to do, but our customers have to have records that they're also complying with the rule. And if you do not have a record, when EPA knocks on your door for inspection, the lack of a record is considered to be a violation. Well, okay, is that a big deal? Well, if you don't have that record, it's $48,000 per substance per day for when you don't have a record that you comply. So if your safety data sheet doesn't specifically have every word that EPA said has to be on the safety data sheet, then every day that you distributed, that manufacturer distributed that substance, that's $45,000. And for some companies, they're like, I don't want that risk. Like, I'm worried that my EH&S person's not going to put the particular word on. They take the word off. Now we're in violation. We weren't aware. That can be millions of dollars of fine. So they just say, we're not going to take these orders and our substances into our supply chain. The other thing is EPA and EPA inspectors, it's not a formal policy, but EPA inspectors have told me this personally to my face. EPA is definitely targeting companies that are manufacturing or processing substances with orders or SNRs. So you increase your enforcement risk by taking these substances in your supply chain, and then you put an enforcement target on your back. So what we're seeing is a lot of folks, not just the manufacturers that are submitting the PMNs, but the folks downstream that are making decisions are saying, we don't want them. We're going to stick with the existing chemicals. We don't care that it's more hazardous. We can manage that hazard because we can manage things safely. We don't want to switch to something that's got a SNR, even if it's safer. And I think for Turi, that's something that should be a concern for you. I don't know if Turi wants to get into the game of trying to help people understand and comply with orders or SNRs. We're certainly working on that with our clients, trying to help. Now our clients, the manufacturers, well, we have clients across the supply chain. Manufacturers are doing more to help their customers understand and help document compliance. But there's still a lot of reluctance in the supply chain there. So if you're innovating, whether you're a company that are innovating or if you're someone that's working with a company that's innovate, you've got a couple options. If you've got a new chemical, what we're seeing a lot of people doing is they're just avoiding TSCA completely. They're like, you know what, it's not worth it. It's too much trouble. It's too much hassle. Data doesn't make a difference. I'm just not going to bother. So you either commercialize outside the United States. A lot of people are surprised. It's easier to go commercial in Europe right now under REACH than it is under TSCA in the United States. You sell in the United States to non-TSCA markets, food, drug, cosmetics. We talked about TSCA jurisdictions at the beginning. And it really does limit the options for new greener chemicals. Again, very frustrating to me personally. What a lot of our clients are doing, innovating, is they're innovating with existing chemicals. They're saying, I'm not going to worry about new stuff. There's 40 some odd thousand things on the inventory. I'm going to innovate with those. So they're looking at what can they do, different formulations, different mixtures, what can they do to innovate within the existing chemical space. And if you're doing that, then the thing to do is just avoid the things that are undergoing Section 6 risk evaluation. Again, EPA's they've got almost 40 for pre-prioritization right now. That's going to take them 8 years. So if you're looking to innovate now, you know what's probably coming in the next 5 to 10, maybe 15 years for prioritization. And if you're just avoiding those existing chemicals, you've probably got a pretty long runway for avoiding things that EPA is going to be targeting for regulation. So this is sort of what we're seeing right now for innovation. New chemicals avoiding the TSCA market, and within the TSCA market, people are innovating with existing chemicals. Real quick, EPA is using their data gathering authority. They're ordering testing under Section 4. It's not as efficient as I think everybody had hoped. I think it's less efficient than Congress had hoped, less efficient than EPA had hoped, and it's certainly frustrating to recipients of the Section 4 orders. The testing is quite protracted. EPA is using its data call-in authority under Section 8D, where EPA issues a rule to require owners of data to submit that existing data to EPA, and 8C, which is a long story. If you have allegations of adverse reactions in your records, EPA is calling that data in too. My experience is the 8C data is really not that valuable in terms of assessing risk. So here's the last point I want to make: opportunities to be involved. The EPA definitely wants input on pre-prioritization. So when EPA says we're considering these 30 things for prioritization, tell EPA what you think. Tell EPA, do this one, not that one. This one's more important. We have, whether it's human health reasons, environmental reasons, whatever reason that you think EPA should be targeting a particular substance, tell EPA that you want them to work on it. Once it's up for prioritization, I understand you have Sarah Al from EPA speaking later. It's not clear to me, once it goes up for pre-prioritization, how there's any way to get it off prioritization. I don't think EPA has a lot of good options once they say we're prioritizing this to not have it go forward. So I think the real opportunity to affect is in the pre-prioritization stage, but Sarah may tell you otherwise this afternoon. Risk evaluation. So during risk evaluation, the EPA very much wants data. They want data on what are the uses, how is it used, is it big, small, big companies, small companies, all those conditions of use. Inform EPA of that. It's very important that EPA understands what the conditions of use are. If you have data, submit that data so EPA has it. There is some debate about whether if EPA does not have data in advance of issuing a risk management rule, if EPA does not have data in advance concluding that someone can manage the risk, that EPA has to ban the substance instead of saying you may use this substance as long as you manage the risk in this way. That is one of the issues that I think will be litigated in the Section 6 lawsuits that are going on. But as it stands now, if EPA does not have data showing that a condition of use is not an unreasonable risk, EPA is seeking to ban it. So it's important to participate in risk evaluation. And then in the risk management rules, it's very important to comment on the proposed rule. Is the rule actionable? Is it going to be protective? Are there other ways to frame it? Are you concerned about the conditions of use that are allowed or not allowed? And does that cover what you need? Again, if you're a TURI, if you're helping people with toxic use reduction, and you're pushing for conditions of use to be banned, comment on that. If you've tried to substitute something that's undergoing risk evaluation and you cannot find an alternative and it is simply unsubstitutable for particular use, it's very important for EPA to understand that as well. And it's also important to comment on the alternatives that are available. Tell EPA what you found, what works. It's often going to be narrow. I mean, right? There's not one substance that's a drop-in replacement for methylene chloride in every condition of use, but there are different substances that can be used in place of methylene chloride for many conditions of use. So all of these things, it's very important to be aware of what EPA is doing and what those rules are going to look like. All right, so we provide a lot of content. Our blogs, you can sign up for all our emails. We write on all this stuff. TSCA, FIFRA, those are our key practice areas. We also do through our consulting affiliate, the Active Group, we do global. So you can sign up for our blogs and see what's happening, what's being proposed, what's gone final, our commentary on it, things to be aware of. It's one way to keep up. Lynn Bergeson hosts a bi-weekly podcast, All Things Chemical. It's free, available wherever you get your podcasts. Very interesting speakers from across the stakeholder community. We have a PFAS resource page. It's hard to keep up. There's a lot going on in PFAS. So you can take a look at that. And then we have, if you need training, our tutors are not free. Everything else is gratis, but our tutor is online on demand. So you can just go on to our website to get training, sign up for these. You pay the for a seat. It gets one person unlimited access for a year for Tosca Tutor, FIFRA Tutor, or GHS Tutor. GHS Tutor is the least mature of the three. But if you need training on these statutes, you can get it basically when you need it. So let me stop there. I appreciate the opportunity to present. Thank you very much for the invitation, Pam. Always happy to talk about Tosca. And I don't know if you want me to answer some of the questions now, or if you want to save them for the panel discussion.
I think, I mean, a lot of information, a lot of good questions coming in from the audience as well. I think maybe we'll go to Kastalie first, and then at the end we can circle back to some of the questions, just to make sure she has time to present.
Yep.
But yeah, thanks so much. A lot of great information, and I can second that the resources of Bergeson and Campbell are extremely useful. So thanks again. And
Sure.
I'll give Kastalie the floor now. I introduced her earlier. She's from the European Commission. She's a policy officer and economist in the Safe and Sustainable Chemicals Unit. Take it away.
Thank you. Can I check that you can see my slides?
Yes.
Okay, that's great. So hi everyone. So as Colin said, my name is Castalie. I'm policy officer at DG Environment at the Commission. So today I'll be presenting on, well, 2 out of the many important regulatory updates from the other side of the pond. So the first one will focus on the communication on the essential use concept, which aims to strengthen our approach in the EU to restricting harmful chemicals. And the second one will be covering actions taken on PFAS in Europe, which is a crucial area right now where we're addressing both environmental and health risks. So I'll start with the first topic on the essential use concept, which is really a key part of our efforts to strengthen chemical regulation in the EU. So I'll walk you through some of the main aspects of a recent communication that was adopted by the Commission and what it could mean for the future of chemical management in Europe. I mean, first of all, you might be wondering why we needed an essential use concept. So the answer to that is relied in a very complicated paradox, which I'm sure all of you are quite familiar with. Many of the most harmful chemicals are actually quite useful. They're versatile. They play critical roles in industries like the green and digital technology sectors. But at the same time, some of the same chemicals pose serious risk to human health, the environment. They're widely present through the EU and beyond as well. And so how do we regulate them? So in 2020, the European Commission introduced a chemical strategy for sustainability. And so that document was laying out steps to phase out the most dangerous chemicals unless they're shown to be essential for society. Then just a few months back in April, the Commission actually took a key step forward by adopting guiding principles or criteria to help define what essential would actually mean for those harmful chemicals. So the concept of essential use really helps us decide when it's acceptable from a societal perspective to use this harmful chemical. So we carefully weigh their importance against potential risks of those chemicals. So the very main goal of the concept was to accelerate the protection of both human health and the environment. It also allows to identify non-essential uses and for those ensure a faster removal of the substances while allowing more time for a controlled phased out in cases their use is actually essential to society. So we hope that this approach can improve regulatory efficiency, but also streamline decision making, and we think it can provide a strong incentive for innovation as well. So what does essential really mean? We thought it would be a more simple task until we realized during some of the consultation that everyone's definition was coming down to something a bit personal. We were quite astonished by the range of responses we got when we asked people what essential was in terms of chemical use. Not 2 people gave the same answer. So that diversity of responses already in the consultation really reflected that a quite nuanced and thoughtful approach was really needed when defining essential uses. So we came up with criteria. So to decide if a use is essential, it should meet both of the criteria that you can see on my slides. So first, it needs to be necessary for health or safety, or critical for society's functioning. Sometimes it's both. And second, there must be no acceptable alternatives to using that chemical. So you could have a use of a chemical that's like very important for health and safety, but if there are acceptable alternatives to that use, then it's not an essential use. We then came up with some general principles or elements of scope. For example, we're evaluating the essentiality of a use of a chemical. We're not assessing the essentiality of substances themselves. We're not assessing specific products or entire sectors. So for example, if you think about the use of a harmful substance in an airplane engine, where it plays a crucial role for safety, is very different from using the exact same substance in an airplane seat or a carpet, where it could be there, for example, for decorative purposes. In addition, the concept does not apply to all the chemicals out there. It really applies to the use of the so-called most harmful chemicals. So these are defined in the European strategy, and they're typically like carcinogens, endocrine disruptors, and others. So in the communication that's publicly available, we came up with a bit more information about what we meant by necessary for health and safety or critical for society. So this is just a snapshot on the slide, but uses necessary for health and safety, they include a range of vital functions. For example, preventing, monitoring, treating illnesses, sustaining basic conditions for life, managing health crises or emergencies, ensuring personal and public safety, among others. And similarly, uses critical for society, they include providing resources or services that must remain in service for society to function, managing societal risks and impacts from natural crises or disasters, protecting and restoring the natural environment, protecting cultural heritage, and so on. Again, so for each of the bullet points that you saw in my previous 2 slides, we actually went a level further or maybe more granular in the communication. So for each of those, we provided a bit more information. So for example, on the bullet on protecting and restoring the natural environment, we further defined this as, for example, uses to reduce and mitigate greenhouse gas emissions, reduce water, soil, and air pollutants, or remediate pollutants in the environment. So these are just a few examples, but I think there are about like 3-4 pages on defined criteria for essential uses in the communication. The context of how a harmful chemical is used is just as important as those criteria. So the assessment will inevitably consider the final product or service. Even if we don't assess whether these products are essential, we take them into account in the assessment. For instance, the use of harmful chemical in a surgical lamp in a hospital would likely be much more critical than the use of that same chemical in a desk lamp or in a shop lamp, where we think the stakes are likely not to be as high. So finally, identifying acceptable alternatives is the last criterion. So that involves looking at substances, materials, technologies, or processes even that can perform a similar function as the harmful chemical, but obviously with lower risks to human health and the environment. So when allowing essential uses to continue, we recommend conditions to be set. So these can be conditions to minimize the emissions and the exposure of human and the environment, to provide information in the value chain, or also to consumers, and to follow the transition to alternatives. And so maybe a last point that's quite important is that the essentiality of a use is not static or permanent. It evolves over time. For example, based on new information, on new societal needs, or emerging alternatives as well. So that assessment should be periodically reviewed in light of that new information. So where we stand now, I think currently there's no EU legislation, and I think no legislation at all, defining essential uses of substances. So introducing this concept into legislation would require setting legal definitions, identifying appropriate procedures and decision-making bodies as well, exploring a bit how this could simplify regulatory processes, not complexify it. I mean, obviously, at the moment, it could already be used in some aspects of REACH. For example, the socioeconomic assessment under authorization restrictions. So there's some possibilities to look at essential uses already there. But obviously, other options, and especially at a time where we're revising REACH, there could be further legal provisions on essential uses, for example, to facilitate authorization of harmful chemicals, but also accelerate restriction of non-essential uses, allowing derogations from restrictions for uses essential to society and so on. In the meantime, and before it's incorporated in legislation, we think the concept can provide quite clear signals on where to focus investments and substitution efforts. So something that offers quite some incentives to drive research and innovation for businesses as well. So now that we've covered the essential use concept, I'll quickly turn to another critical area, which is PFAS. And so I'll just update you a bit on some actions taken in Europe to address these substances. I'm quickly gonna, given that we're a bit running out of time, I'm sure a lot of you are quite familiar with the problem of PFAS and the fact that there are so many substances used in so many important sectors and the persistency issue that they come with. So in 2019, the Council in Europe asked the European Commission to create an action plan to eliminate all non-essential uses of PFAS. And this led to the Commission's Chemical Strategy for Sustainability, the one I've mentioned earlier about essential use concept, in 2020, which aimed to phase out PFAS across the EU unless they're considered essential for society. The European Parliament also added its voice that very same year, calling for a quick phase out of all non-essential PFAS uses and encouraging the development of safer alternatives. So together, these actions really reflect strong momentum from the Council, the European Parliament, the European Commission, to reduce the reliance on PFAS and support safer, sustainable solutions. So the EU has already taken several actions to address PFAS. For example, under REACH, which is our main legislation on chemicals. So we currently have a number of restrictions in place. They limit the manufacture, the use and the placing on the market of certain PFAS substances. So you can see some of those in my slides. And at the moment, the Commission is in the final stages of implementing a restriction on PFAS in firefighting foams as well. In addition to that, the EU has been taking further action to tackle PFAS under legislation other than REACH, and also across multiple environmental media. For example, some PFAS are already regulated under the POPs regulation. So these are substances like PFOA, PFOS, or PFH excess. And some additional long-chain PFCAs are proposed for listing as well. In terms of water, PFAS parameters were added to our drinking water directive in 2020. So that sets strict limits for both individual and total PFAS concentrations. Also, PFAS and its derivatives are considered priority hazardous substances in surface water. And several PFAS are now monitored in what we call a water framework directive. So that's in groundwater. In addition, we have a new industrial emissions directive, which is also strengthening the monitoring and control of PFAS emissions from industrial sources. And as for food, there are also some maximum concentration levels for certain PFAS in food. And there's ongoing effort to monitor PFAS in food as well. So maybe just my final slides is getting to this, what we call universal PFAS restriction, which is covering all PFAS. So that process for a broad restriction on all PFAS began when 5 countries, 4 from the European Union and Norway, came together to submit a restriction dossier. So that dossier is currently under assessment by the scientific committees at the European Chemicals Agency. So these committees are the Committee for Risk Assessment, we call them RAC, and the Socio-Economic Analysis Committee, they're known as SEAC. So these committees will each provide their opinions ROC focuses on risk assessments and SEAC addresses socioeconomic factors. And based on these assessments, the Commission will then develop a formal proposals for how to proceed with the PFAS restriction. So given the really vast scope of this dossier, it's covering about 10,000 substances across more than 14 sectors. The committees have decided to take a sector-specific approach for the evaluation. So we're discussing each sector one at a time. And this has led to a very large number of comments. I think we got a bit over 5,000 comments during a first public consultation. So the opinion development process by the European Chemicals Agency will continue through 2025. And following that, a second public consultation will be held on particularly the socioeconomic draft opinion only, so that third parties can provide further socioeconomic information like on alternatives and cost and so on. So once the committees have finalized their opinions, the Commission will step in to prepare its formal proposal. And so the aim of the Commission will really be in this restriction to take all necessary steps to protect the health of citizens and the environment, was giving sufficient certainty to EU industry that the production and use of certain type of PFAS, those that are used in critical industrial processes, for example, and that cannot be substituted, can continue to be used for a period of time for alternatives to be found. So that was just a bit what we're doing on PFAS. I mean, obviously, I'm sure there might be some questions, some thoughts from the audience. So I'll be happy to take any if we have some time left. Thank you.
Thank you, Kastalie. Two very tricky and connected topics that we're grateful to have the European Commission working on to further develop. I'd encourage everybody to keep an eye on what's going to happen in Minnesota, which is a state in the United States, which will be implementing the essential use concept in the context of PFAS to what is my knowledge, the first time ever. So that's a useful resource. We don't have much time, unfortunately. I will try to ask one question that takes into consideration some of what's being said in the chat and what you and Rich have both said. One thing that surprised me during Rich's presentation is that companies are actually going to the EU to pass through the use of new chemicals because it's easier than under TSCA. So maybe Rich, you could expand a bit on what are they doing under REACH that makes that easier? And then also what can stakeholders in the US, Massachusetts and beyond, both regulators and companies, do to make that process a bit easier to avoid some of the situations you're talking about?
So in REACH, getting to market is fairly straightforward. You develop the data, you submit the data to ECHA, and you can proceed to market. Under TSCA in the United States, it really doesn't matter what data that you have. Whether you have data or not, the EPA is going to evaluate the substance based on models, analogs, and your data. Sometimes EPA uses models and analogs in preference to data on the substance because it gives them a more conservative number. We've been battling that, but basically what we're seeing is that under TSCA new chemicals, they're looking for a reason to regulate everything. And once they find that reason, they issue a regulation and they go on. And so we end up with things that are getting marginalized in the market, things that really should be things with lots of data to show that they're actually quite safe. They don't meet that low hazard threshold. Right? Again, if you don't meet EPA's low hazard threshold, the EPA will issue a regulation. You will be restricted in some way, and then that's what you're battling in the market, in the marketplace of not just ideas, but actual, what companies want to purchase and what risks do they take from enforcement. Things with orders and SNRs are losing. In Europe, you have a level playing field because everything, all new and existing chemicals, have to go through the registration process. So if you think that's a problem, you can certainly advocate, talk to your folks in Congress about. We've been trying now for a couple of years to get EPA to take a more measured approach, a less absolute approach to TSCA new chemicals. We've actually, in fact, launched the Coalition for Chemical Innovation to try to convince people that what EPA is doing is not only not complying with the law, but also significantly disadvantaging the economy and public health and the environment in the United States.
Thank you. We are over time. I'll just ask Kastalie one question. You know, the PFAS restriction process is ongoing and gigantic. Are there opportunities for businesses in other countries to comment on what's happening or to be involved and engage? And are you guys keeping an eye on how PFAS might be legislated in states in the United States or how they're used while you develop that?
I'm sure. I mean, first of all, there's been a public consultation, I think in 2023, which was open to everyone, literally. So it's not just EU businesses that can submit information. And I think we got quite a significant number of contributions from non-EU businesses. And there will be another consultation on the socio-economic aspects of the restriction of PFAS. And this is, again, a consultation that's open for EU and non-EU businesses and any stakeholders, actually, not just businesses. Just on ourselves at the Commission, we're now observers in the PFAS restriction process while these are being assessed by the committees of ECHA. But we're looking very much at what's going on, you know, within some of the countries in the EU as well, because some of the member states are taking steps forward in legislating on PFAS, but also what's going on in other parts of the world as well. So definitely looking at the US, Canada, and some of the Asian countries as well.
Great, thank you for that. Looks like we're over time. I think we could speak on this for another hour, it seems, but unfortunately, there are other sessions to be had during the conference. We'll possibly consider sharing the recording of this event. We'll definitely get out some sort of written summary because it's a ton of information and all very useful. So thanks very much to our speakers for joining us. And yeah, looking forward to the next session. Thanks again. And with that,
Thank
I'll
you all.
close.
Thank you very much. Bye.
Bye.